Attorney General. Attorney General. See, when you talk about the Indian legal system, the Indian legal system is in fact a mixture of American legal system plus British legal system. Fine. This is a mixture of American legal system as well as the British legal system. So you will use different terms. Say for example, lawyers. Then you use the terms like, say for example, barristers. Barrister in Britain. Advocate, solicitor, and even attorney. All those have the similar meaning. But in different legal system, we use the different terms. In India, we use solicitor, attorney, advocate, etc. Why? Because we have adopted the most beautiful features from the non-constitutions in the world. So that is the reason why you would have heard about Solicitor General of India, Attorney General of India, Advocate General of India, isn't it? You would have heard about different terms. Yes, all are basically advocates, lawyers, barristers, but we use different terms. So when you talk about Attorney General, the term Attorney General means attorney is advocate, general means chief or important. In other words, Attorney General means it is the Chief Advocate of India. Chief Advocate of India means he or she is the advocate of union government. Okay, so basically, or in simple terms, Attorney General means he is in fact the advocate of the union government. Say for example, if I wanted to hire an advocate, okay, say for example, I wanted to present a case. I might not be knowing that legal, say for example, the legal complications or formalities inside a court. So that will be in fact dealt by an advocate who has in fact pursued law as their studies, or academically they might be lawyers. So such a kind of advocate who will take the cases or the briefs of the union government is what do you mean by Attorney General. So basically he is the advocate of union government. Fine. So that is what is the concept of Attorney General. Now we will try to understand all those important matters. We have understood about attorney means it is advocate. He is the highest legal officer or highest law officer, or even the chief law officer of the country is what is the Attorney General. And when it comes to article number that deals with Attorney General, see, Attorney General, of course, you know that Part 5 of the Indian Constitution deals with the union government, isn't it? Part 5 deals with the union government, and it starts from article number 52 to 151. Article number 51A deals with the fundamental duties. 52 to 151 deals with part 5, that is union government. Under union government, you have the first chapter, that is union executive. Union executive consists of the President of India, the Vice President of India, the Prime Minister, Union Council of Ministers, and finally, the Attorney General of India. In other words, starting from article number 52 to 78, you have the union executive. Okay, so in fact, when you talk about article number 74, you have, what does article number 74 say about? 74, very, very important. 75 is further important. 76, very, very important now. 77 and 78, not so important, but still we need to understand. 74 says that there shall be Council of Ministers headed by the Prime Minister to aid and advise the President of India. 75 says about the appointment of the Prime Minister and the Council of Ministers will be done by the President of India. 77, 78 again deals with the executive and the council of ministers. Now, what is 76 dealing with? 76 deals with the Attorney General of India. Okay, article number 76 deals with the Attorney General of India. He is not a cabinet member, he is not a minister. Okay, he is not a cabinet member, and even he is not a government servant. In other words, he is not a government official. Does not make this as a confusion. He is not a government official. He is just a private practitioner. The government has appointed as the advocate of that particular government. Fine. So he is not a cabinet member. He is not a government servant. He is only an advocate appointed by the union government to file a brief in the Supreme Court. Fine. So this is what is the basics regarding the Attorney General of India. The highest law officer, article number 76 says that regarding the Attorney General, not a cabinet member and not a government servant. Now, yes, regarding the appointment of the Attorney General, who will be the appointing authority of Attorney General? Of course, the answer is the President of India. So the appointment will be done by the President of India. In other words, the President of India will be doing the appointment on the aid and advice of the Prime Minister and the Council of Ministers, because ultimately the Attorney General is the advocate of the Union. So that will be on the basis of the aid and advice of the Prime Minister and the Council of Ministers. Now, what are the qualifications for a person to be appointed as Attorney General of India? The Constitution says that the qualification required for a person to be appointed as the Attorney General of India is all the qualification which is required to be the judge of Supreme Court. Okay, all the qualification which is required to be appointed as the judge of the Supreme Court, the same qualifications are in fact required for the Attorney General of India. So what are the qualifications that is required for the judge of the Supreme Court? Advocate of Delhi High Court. Advocate of 10 years of experience as an advocate. Okay, fine. Then 5 years. Judge of High Court, 5 years, very good. 10 years experience as an advocate of all the courts. Lost. Advocate officer means he should be a person inside the office of any advocate. Supreme Court advocate, very good. Experienced jurist, Indian citizen. Yes. Okay, very good, fine. So if a person is Indian citizen, that person is qualified to be an Attorney General. One of the qualification is citizen of India. Okay. So in fact, keep in mind that regarding the qualification of judge of Supreme Court, the same qualification is applicable for Attorney General also. Regarding the qualification of judge of Supreme Court, this is what you need to understand. Okay. Or you may say it is not plus. A plus B or C or D. I'll tell you. A is citizen of India. In other words, suppose if UPSC asks you which among the following is the compulsory qualification for a person to be appointed as the judge of the Supreme Court, the answer is citizen of India. Compulsory qualification. Fine. Now, this is compulsory, and out of these three, anyone, that is A plus B, A plus C or A plus D, any one is required. Fine. It is not A plus B plus C plus D. No. A plus B or A plus C or A plus D, which means citizen of India plus judge of any high court for 5 years. Okay. Judge of any high court for 5 years and you are a citizen of India means yes, you are qualified to be an Attorney General. Sir, if you are a judge of more than one high court, that means within 5 years, you have got served as the judge of Kerala High Court, Madras High Court, Allahabad High Court, then is he qualified to be an attorney general? Yes. Okay. When you see this, any high court means, it does not mean that he needs to be dedicated to one high court. No, he can be moving also. Fine. The condition is that 5 years experience as the judge of high court. So citizen of India plus judge of high court for 5 years. Congratulations. You have got the qualifications to be appointed as the Attorney General of India, which means he has the qualification to be appointed as even the judge of the Supreme Court. Fine. Now, so this is A plus B. So this is one qualification. Now the next qualification is A plus C. So A is citizen of India. Now what is C? C is in fact 10 years experience as an advocate of any high court. It is not any particular court. He needs to be an advocate of any high court for 10 years. Suppose if he is advocate of Supreme Court, is he fit to be appointed as the Attorney General or the Supreme Court judge? He was not an advocate of High Court, but he is an advocate of Supreme Court for 10 years. That means he has more qualifications than what is required. What do you think? Can additional qualifications be considered as a disqualification? Is additional qualification be a disqualification? Do you think? The minimum qualification for a person to apply for the civil services examination is a graduation. Suppose you are a postgraduate or you are a PhD holder. Can UPSC say that, sir, we have only said about graduation? You are way far. You should not apply for this exam. Can the UPSC say so? No. In other words, he can be the advocate of High Court or even any other court which is above the High Court. So you might have heard about Indu Malhotra, the judge of Supreme Court. She was the former judge of the Supreme Court, and she was not serving as an advocate of any high court. She was serving as advocate of Supreme Court. Fine. So the qualification was advocate of High Court, but she was the advocate of Supreme Court. She has additional qualification. Can that be considered as a disqualification? No. But your PSC will consider, Kerala PSC. In Kerala PSC, additional qualification is a disqualification. Say, for example, there are certain exams I'm not very sure about regarding the category of exams and all. LGS exam or something in which, yes, 10th level exam, which says that those candidates who have got a graduation is not supposed to apply for that exam. For PSC, additional qualification is disqualification. Okay, fine. Yes. Yeah. So this is in fact A plus B. This is in fact A plus C. So even this qualification is required. Now, what is A plus C? Citizen of India and eminent jurist in the opinion of the President of India. Citizen of India and eminent jurist in the opinion of the President of India. Fine. So these are in fact the qualifications required for a person to be the judge of the Supreme Court, as well as for a person to be appointed as the Attorney General of India. The same qualification is what is applicable for the judge of the Supreme Court as well as the Attorney General of India. So this is A plus C. So that is why I have told you that it is the format is A plus B or C or D. Fine. Now, when it comes to the term of Attorney General is not fixed. Okay. The term of Attorney General is not fixed by the Constitution of India. Yes. So regarding the term of the Attorney General, it is not fixed by the Constitution. In other words, Attorney General serve during the pleasure of the President of India. See, what do you mean by this? What do you understand from this? There was a question for this year, I think, regarding the Attorney General, and the question was that the term of Attorney General is 5 years, and it is something which in which you can just apply your common sense again. Suppose if you hire an advocate, okay, you hire an advocate, can you give him fixed condition of service for 10 years? Suppose if that advocate is not an efficient person, what will you do? You will change the advocate, isn't it? And if the union government feels that this person is not, in fact, considering the cases of the union government serious, they will remove that person, isn't it? So that depends on the efficiency of the advocate. So that is the reason why the constitutional forefathers decided that we will not fix the term of Attorney General of India. Why? Because he is, in fact, the advocate of the union government. And if the union government feels that this advocate is not performing up to the mark, then they may remove that person. So that is the reason why the term of Attorney General is not fixed by the Constitution of India. It is during the pleasure of the President of India, which means it is as per the decision of the central government. So here the pleasure of the President does not mean it is majority in Lok Sabha. No, it means the decision of the union government. So when you talk about the Attorney General, he will serve in the office as per the decision of the union government. Fine, during the pleasure of the President of India. Okay, fine. Now, what are the procedure and the grounds for removal for the Attorney General? Is there any procedure? Say, for example, this kind of majority is required for the removal of the Attorney General, or there is some grounds for the removal, say, for example, incapacity. Is there something mentioned in the Constitution? No, nothing is mentioned. It is totally the decision of the central government. Okay, so nothing gets mentioned regarding the procedure as well as the grounds for the removal of Attorney General. So does he has the security of tenure? No, he does not have the security of tenure. He does not have the security of tenure. In other words, he can be removed any time by the President of India as per the decision of the central government. There is no security of tenure given for the Attorney General. Does the governor has the security of tenure? Governor of the states. What is the term of the governor? Not fixed by the Constitution. The term of the governor, in fact, needs to be specially given some attention. Why? Because the governor is always in news now. UPSC is very interested regarding governors. In fact, it is fixed. Yeah, but there is one problem. I'll tell you. Regarding the term of the governor, what is mentioned in the Constitution is that the term of governor is 5 years, subject to the pleasure of the President of India. Which means once a governor is appointed, he can serve for a maximum period of 5 years. But is it a security of tenure that he will be in position as governor for that 5 years? No. Because that also lies with the decision of the central government. Because governor is a political appointment, totally political appointment. But one thing is sure, that the governor Saab, you are supposed to remain in the office only for 5 years, once appointed at a time. Can he be reappointed? Yes, he can be reappointed also. But one appointment can only make that governor to sit for 5 years. Suppose if Narendra Modi recalls Arif Muhammad Khan before 5 years, can he go to the court and say that Mr. Modi is violating the constitution? No, because the constitution clearly says that it is subject to the pleasure of the president. Sir, your term is 5 years, but it is always subjective to the pleasure of the president of India. You can remain 5 years, but it is always subject to the pleasure of the president of India. Clear? So that is very, very important. Do not forget about this. Fine. So there is no security of tenure for the governor as well as the attorney general. And who will submit the, or to whom the attorney general will submit the resignation to? Of course, to the president of India. And who will decide the salary of attorney general? Is it the Parliament of India? No. Who will decide the salary, determine the salary? Absolutely. It is the common sense which again needs to be applied here, because if I am hiring an advocate, his salary will be determined by me. If Parliament is going to determine the salary of Attorney General, then the opposition will say that, sir, this advocate is not so efficient. So do not give that salary. Isn't it? So the salary will be determined by, the remuneration will be determined by the President of India. And it is not the decision of the President of India. It will be the decision of, in fact, the Prime Minister and the Council of Ministers. Okay. Now, we will just finish it. Only simple things now. Regarding the duties and functions. Number one is that the Attorney General advise the government of India on reference by the President of India. Suppose if there is any legal matters coming in front of the President of India, and the President of India may ask the Attorney General to please give the legal advice to the government of India. So in that case, the Attorney General will have to tender the advice to the government of India. The second one, appear on behalf of government of India. Say, for example, if there is a case like Shankari Prasad versus Union of India. Shankari Prasad versus Union of India. Who will be representing the Union of India? That will be the Attorney General of India. Okay. So the Attorney General of India will be representing or appearing on behalf of the Union government of India. Now, what does article number 143 speak about? 143, article number 143. Article number 143 of the Indian Constitution speaks about the advisory jurisdiction of the Supreme Court. What is it? Advisory jurisdiction of the Supreme Court. Suppose if the president has any doubts regarding a legal matter or a pre-constitutional matter, the President of India can seek the opinion of the Supreme Court of India. Okay, the Supreme Court of India. So who will go for the President of India to the Supreme Court? Can the President go himself to the Supreme Court of India and ask for the advice? No, that will be in fact given by the Attorney General of India. Fine. So the Attorney General will be representing the President of India to get the advice of the Supreme Court under article number 143. The next one, appearance in the High Court when required for the government of India. So basically, Attorney General will be representing the Union government in the Supreme Court of India. Usually, it is the matter. In the Supreme Court of India, the Attorney General will be representing the Union government of India. But if there is a case that needs to be represented in a High Court also, if the case actually necessitates such a kind of situation, Attorney General can even represent the government of India in a High Court also. If the President says the Attorney General, please go and represent the government of India in the High Court, then he can be represented at the High Court also. Usually it is the Supreme Court, but if there is the President of India asking the Attorney General to represent the government of India at the High Court, even at the High Court level, the Attorney General can represent the government of India. Fine. Now, what are the rights of Attorney General? The Attorney General has got the right of audience in all courts as part of official duty. What do you mean by this? Right of audience in all courts as part of official duty, which means the Attorney General of India can attend the proceedings of all the courts within the territory of India as part of his official duty as the representative of the government of India. Okay, he can hear all the cases. He can be an audience in all the cases in any courts within the territory of India for his official duty. He can even attend the parliamentary proceedings also. Okay, he can even attend the parliamentary proceedings, including the joint sitting. He can take part in the proceedings. He can speak. Okay, he can even conduct speech. He can give advice to the PM and the Council of Ministers regarding what needs to be said in the House. All those things can be done by the Attorney General of India. But he is not supposed to. Yes, there is no voting power for this person. And this guy will have all the privileges and immunities and MP usually enjoys in the parliament, which means he will be having, say for example, just like an absolute freedom of speech and expression inside the parliament. So those immunities enjoyed by the members of the parliament will be in fact enjoyed by the Attorney General of India also. But there are certain limitations. Being said so, we say that, yeah, fine, Attorney General, he is a great person, great man. But even said so, the Attorney General has got certain limitations. What are those limitations of Attorney General of India for this particular constitutional office? One of the conditions is that he should advise or hold a brief against government of India. Just correct, he should not advise or hold a brief against government of India. What does that mean? Suppose if you are appointing an advocate, can you say that, sir, you should be 24 hours or 24/7, you should be an advocate for me. I will be active in criminal activities. So you will be provided with the security of tenure for the entire life. You will be provided with enough number of cases. I will give you the cases. You should not go, you should not take the brief of any other parties. I will give you the requirements. If you need to take forward your career, I will give you the cases. You just tell me what kind of action should I do. I will do that. But you should not go anywhere else. Can it be? So can the government of India say that you are not supposed to take any cases else? You should only consider my cases. Will any advocate be willing to take such kind of action? No. Why? Because the security of tenure for the government of India is only for 5 years. And even for 5 years, there is no security. After 5 years, what will this person do? Isn't it? So the government of India can say one thing. That is, if the case is against me, you should not take the case. Fine. So the government of India says that you should not advise or hold a brief against the government of India. Sir, if I am the opponent, if I am the party of the case, you are not supposed to advise my opponent. Fine. So if the case is with the government of India and another party, you should not give help for this party. If such a case, if the nature of this case is like this, You should be always with the government of India. So that is practical, isn't it? That is practical. Otherwise, can we say that you are not supposed to take forward any private practice? Can we say? No, that is not supposed to be. And he should not defend accused in criminal prosecutions without the permission of the government of India. See, even those accused in criminal actions, such persons' brief should not be taken by you without the permission of the union government. You can take it, but before that, you should ask for the permission. Otherwise, there can be a perspective made that the advocate of the union government is in fact getting a brief against an accused in the criminal case. Isn't it? Attorney General is in fact the advocate of the union government. And this advocate or attorney general is in fact defending a person who is accused in the criminal prosecution. So that can give a negative image for the government of India. So before getting into such kind of actions, you should seek the permission of the government of India. Now, is Attorney General a full-time counsel of the union government? Is it a full-time job? Attorney General, is it a full-time job? Another way of asking the same question is that, can he go for private practice in case if there is no work given by the government of India? Yes, of course. It is not a full-time counsel. It is not at all a full-time counsel. He can even take forward his private practice. Fine, he can take forward his private practice. It is not a full-time counsel at all. So this is what you need to understand regarding the Attorney General of India. Okay, these are the things which you need to understand regarding the Attorney General of India. So the first constitutional office is done. The most important being is that regarding the term, regarding the limitations, the term is not fixed by the Constitution of India. The limitation is that he is not supposed to hold he is not supposed to hold a brief against the government of India in which the government of India is a part of that case. Okay, so those are the things that you need to understand regarding the Attorney General of India, whether he has the security of tenure. No, he does not have the security of tenure. Clear? The same system exactly is applicable to Advocate General of India at the state level. Exactly the same system is applicable to the Advocate General of India at the state level. Okay, so just read Advocate General of India also while you prepare Attorney General. That's it. It's not something which is big deal. Just read it. If there is president, you will see governor. That's it. Exactly the alternative at the state level will be provided. Fine. All those systems otherwise are same at the state level also. Appointment will be done by the governor. Resignation will be submitted to the governor. Fine. All those things are similar when it comes to the state level. Clear? Fine.